Welcome to Legal Minds. Today we're in the sphere of contract law. You know, when you're talking about contracts are made every day. In our day-to-day living, contracts are made every time. So it's important sometimes to understand contracts. However, today we're just going to talk about vitiating factors. Now, what are vitiating factors in the sphere of contract law? Vitiating factors, these are factors that invalidate a contract or they affect the validity of a contract. So, there are 5 recognized vitiating factors. The first one is mistake, misrepresentation, duress, undue influence, and legality. So today we're going to talk about mistake. We're going to define what a mistake is, mistake that affects the validity of a contract, and mistake that do not affect the validity of a contract. We are going also to discuss types of mistakes, and furthermore, we're even going to discuss the remedies of a mistake. So let's start with the definition of a mistake. What is a mistake? When we're in contract, a mistake is an erroneous belief or opinion about something. There are certain types of mistakes that do not affect the validity of a contract. So what are those types of mistakes which cannot affect the validity of a contract? The first one is mistake of law. There is a legal maxim which says that ignorantia hand juris excusat, meaning ignorance of the law excuses no one. So there is a general presumption that everyone knows the law of their own country, except from the law of other countries. So it is no defense that I didn't know the law, that's why I did this. Now, when we're in the sphere of contract, one maybe can say that I didn't know that the law prohibits such kind of contracts. It is not a defense. You are supposed to know the law. The second type of mistake which will not affect the validity of the contract is a mistake as to a trade term, as to the meaning of a trade term. So you are negotiating, you are making a contract, then you don't understand the meaning of a trade term, a term that is in the contract. You don't understand its meaning. So you cannot claim that I entered into this contract under a mistake because I didn't know the meaning of this term. And the third one is an error of judgment as to the value or quality of the subject matter. This one is very common, colleagues. You say you entered into a contract because you made a mistake as to the quality of the subject matter. For example, a simple example that I can give is whereby you buy something. That's a contract. You buy something. Then that thing that you have bought is of poor quality. You cannot return that product saying that the reason why you bought that thing, you thought it was of good quality. That kind of mistake can only affect the validity of a contract if there was a misrepresentation. But if there was no misrepresentation, it will not affect the validity of the contract. Now, we have to talked about the mistakes that will not affect the validity of the contract, let's talk about the types of mistakes, the other types of mistake that will affect the validity of the contract. So these are generally known as operative mistakes because they affect the validity of the contract. The first one, mistake as to the signing of a written document. The second one, mistake as to the identity of one party. And the third one, mistake as to the subject matter. So, under the first one, the presumption is that where a person signs a written document, is presumed to have understood the contents and the terms of the contract of the document that he has signed. So when you sign something, a written document, you should read and understand the nature and the contents of that document. Because the law, there is a presumption in law that you have read and you have understood. But however, there is a defense to this kind of mistake. And it is non-ist factum, which means it's not my deed. Now it has elements. For you to raise the defense of non-ist factum, you have to satisfy the three elements. The first one is the document signed or the signature was induced by fraud. The third, the document signed is fundamentally or radically different from that which thought to be signed. And the third one, the signatory must exercise reasonable care. He or she must not be negligent when signing that document. So now, this mistake as to the signing of a written document, it originates from a case of Lestrange versus Greco, a 1934 case. So this case was based on an exemption clause where the claimant, the plaintiff, or in short, in this case, she's the plaintiff. She bought a vending machine, and when she bought, she signed a sales agreement which contained an exemption clause limiting or exempting the defendant, who were the seller, from liability. So, upon buying that vending machine, she realized that the vending machine was defective. Then she brought an action in contract to sue. But the House of Lords ruled that when you sign a document, there is a presumption in law that you understand the contents of the document you have signed. Hence, she lost the case. Now, the case which establishes these elements of non-ist factum, which I was stating, is the case of Saunders vs. Anglia Building Society. You should look at that case so that you can understand this. Let's go to the third, the other mistake which can affect the validity of the contract. Mistake as to the identity of one party. This type of mistake is generally a unilateral mistake because one party is the one who is mistaken, who has made the mistake, and the other party ought to have known or must have known of the mistake. The third one is mistake as to the subject matter. When we're talking of mistake as to the subject matter, it applies, it can either be a common mistake or a mutual mistake.